Good evening, Dean. Good evening, classmates. I am Miss Angeles L. Abesha. I am the first reporter of Group 5 and I will be reporting to you the assigned topics under strict liability. The cases as well as the multiple choices questions will be presented separately by one of our group mates who is assigned on that. Topic 1 is the responsibility of the possessor of animals. The possessor of an animal, or whoever may make use of the same, is responsible for the damage which it may cause, although it may escape or be lost. This responsibility shall cease only in case the damage should come from force majeure or from the fault of the person who has suffered damage. This is according to Article 2183 of the Civil Code. This article further explains that the possessor is liable even if the animal should escape or be lost and so be removed from his control. The obligation imposed by this article is not based on the negligence or on the presumed lack of vigilance of the possessor or user of the animal causing the damage. It is based on natural equity and on the principle of social interest that he who possesses animals for his utility, pleasure, or service must answer for the damage which such animal may cause. The topic for strict liability is about products liability under Article 2187. According to this article, manufacturers and processors of foodstuff, drinks, toilet articles, and similar goods shall be liable for death or injuries caused by any noxious or harmful substances used, although no contractual relation exists between them and the consumer. The basis of this product's liability. First, according to the law, the responsibility is put upon who sends goods outside into the channels of trade for use by others. Second, we also have this RA number 7394 or the Consumer Act of the Philippines. According to enterprise liability principle, a manufacturer is strictly liable for the torts when an article he places on the market, knowing that it is to be used without inspection for defect, proves to have a defect that causes injury to human beings. When is a product considered defective? First, when it does not offer the safety rightfully expected of it, taking relevant circumstances into consideration, including but not limited to presentation of product, 2. Use and hazards reasonably expected of it, and 3. The time it was put into circulation. Is a product not considered defective? A product is not considered defective just because another better quality product has been placed in the market. When is the tradesman or seller liable? According to the law, the tradesman or seller is liable when, first, it is not possible to identify the manufacturer, builder, producer, or importer. Second, the product is supplied without clear identification of the manufacturer, producer, builder, or importer, and he does not adequately preserve perishable goods. In relation to the previous slide, the remedy of a party who makes payment to the damaged party is to exercise the right to recover a part of the whole of the payment made against the other responsible parties, in accordance with their part or responsibility in the cause of the damage effected. We are all familiar of the principle of cavit emptor, which means that let the buyer beware. So the question is cavit emptor applies to the purchase and sale of drugs? According to jurisprudence, this principle cannot apply to the purchase and sale of drugs because the druggist is responsible as an absolute guarantor of what he sells. In one decision by the Supreme Court, it says that cavit emptor is not applicable. It should be cavit vindicator or let the seller beware, by which goods are covered by an implied warranty of mercantility in cases of selling of drugs. In relation to this principle, we have this landmark case, Mercury Drug versus Baking. This will be discussed later by one of our group mates who will discuss cases and multiple choices bar questions which are all related to our assigned topic. Another very important topic of strict liability is nuisance. According to Article 694, nuisance is any act, omission, establishment, business, condition of property, or anything else which first is injures or endangers the health or safety of others. The examples are prostitution houses, firecrackers factory, an old story house which is in danger of collapsing, and a dump site in an area near an existing subdivision. Second is nuisance, a noise or offense the senses. What are the examples? First is coal-fired thermal plant which caused too much noise and pollution to the residents of a barangay or town, or a water pumping station located near a residential houses. Third is nuisance shocks, defies or disregards decency or morality. Examples are massage parlor where there are also prostitutes, disco pub which exhibits naked dancers, house with video disc showing indecent films and videos. Fourth is nuisance obstructs or interferes with the free passage of any public highway or street, or any body of water. Examples are market stalls in public streets, basketball courts in public streets, squatter shanties in creeks or very near the seashore. Fifth is nuisance hinders or impairs the use of property. Example, an ihaw-ihaw restaurants constructed without permit on the street. What are the classifications of nuisance? According to Article 695 of the Civil Code, nuisance is either private or public. A public nuisance affects a community or any considerable number of persons, although the extent of the annoyance, danger, or damage upon individuals may be unequal, while a private nuisance is one that is not included in the above definition. Another classification is also nuisance per se and nuisance per accidents. The former is always a nuisance at all times and under all circumstances whenever it may be located or found, while the latter becomes nuisance because of the location and other circumstances. It is not nuisance by its very nature. To further illustrate nuisance per se, my groupmate will discuss to you Sichon et al. Versus Aquino. This will answer whether or not the houses constructed in the public streets is considered as nuisance per se. Question: what is the liability of a successive owner or possessor of property who refuses to abate a nuisance? According to Article 696, that successive owner or possessor is liable in the same manner as the former owner or possessor of the property. To proceed, let us discuss remedies on issues regarding public and private nuisance. So what are the remedies of a person injured by nuisance? Such person can seek the abatement of the nuisance or recover damages or do both. According to Article 697, the abatement of a nuisance does not preclude the right of any person injured to recover damages for its past existence. What about remedies against public nuisance? According to Article 699, the remedies are prosecution under the revised penal code or local ordinance if any, civil action, or abatement without judicial proceedings. How about remedies against private nuisance? In this case, there are only two remedies. First, civil action or abatement without judicial proceedings. Can a private individual institute civil action to abate public nuisance? According to Article 704, the answer is yes, provided that all the requirements of this article must be complied with. So what are the requirements of this article? Number 1 is demand. Number 2, this demand must be rejected. And number 3, the abatement must be approved by the district health officer with the assistance of the local police. And number 4, the value of such destruction does not exceed 3,000 pesos. Can a private person abate a public nuisance? The answer is yes, by removing or if necessary, destroying the thing which constitutes the same without committing a breach of the peace or doing unnecessary injury. Lastly, let us discuss this famous doctrine of attractive nuisance. What is this? Accordingly, One who maintains on his premises dangerous instrumentalities or appliances of a character likely to attract children at play and who fails to exercise ordinary care to prevent children from playing therewith or resorting thereto is liable to a child of tender years who is injured thereby, even if the child is technically a trespasser in the premises. However, this doctrine does not apply to bodies of water, natural as well as artificial, in the absence of some unusual condition or artificial feature other than the mere water and its location. What are the basic elements of attractive nuisance? First, a potentially dangerous condition exists on the property and the landowner created or maintained the potential hazard and he have known the condition would attract children and that condition could harm such children. The most common attractive nuisance based on jurisprudence are swimming pools, construction sites, power lines and high voltage towers, man-made ponds, lakes, and fountains. The landmark case of the doctrine of attractive nuisance is Hidalgo Enterprises Incorporated versus Balandan, which will be discussed to you by one of our group mates.
General principles of damages. Damages is the sum of money which the law awards or imposes as pecuniary compensation, recompense, or satisfaction for an injury done or a wrong sustained as a consequence either of a breach of a contractual obligation or a tortious act. It is different from injury and damage. Injury is the illegal invasion of a legal right, while damage is the loss, hurt, or harm which results from the injury. The award of damages is based on the principle of just compensation. It is indemnity or reparation for the loss or injury sustained by the injured party so that he may be made whole and restored as nearly as possible to the position or condition he was prior to the injury. The rule is that when it is no longer possible to return the object of the contract, an indemnity for damages operates as restitution. The important consideration is that the indemnity for damages should restore to the injured party what was lost. Damages are either general or special. General damages are such as natural and necessarily result from the wrong. These are awarded for the direct physical and or psychological effects of the wrong. Example, physical pain and suffering and mental pain and anguish. However, special damages are such as have proximately resulted but do not always immediately result from the breach. It is and will not therefore be implied by law. For example, medical expenses and the loss of income. So the difference between the two is that general damages need not be specially pleaded and may be embraced in the general phrase for such other relief as may be deemed just and equitable under the premises. However, special damages must be specifically paid for. If any special damages has also been suffered, it should be set out in the pleadings in accordance with Jimenez versus Reyes. According to Article 2197 of the New Civil Code, the damages may be classified as 1. Actual and compensatory, 2. Moral, 3. Nominal, 4. Temperate or moderate, 5. Liquidated, and 6. Exemplary or corrective. So, as a brief overview, actual and compensatory damages are those awarded in satisfaction of or in recompense of loss or injury sustained, while moral damages are awarded to enable the injured party to obtain means, diversions, or amusement that will serve to alleviate the moral suffering he has undergone by reason of the defendant's culpable action. On the other hand, nominal damages may be awarded in order that the plaintiff's right may be vindicated or recognized, and not for the purpose of indemnifying the plaintiff for any loss suffered. Temperate damages may be recovered when pecuniary loss has been suffered, but the amount cannot, from the nature of the case, be proven with certainty. The amount is left to the discretion of the courts. Liquidated damages, on the other hand, are those agreed upon by the parties to a contract to be paid in case of the breach thereof. Parties are allowed to stipulate on the liquidated damages to be paid in case of breach. And exemplary damages are imposed by way of example or correction for the public good. Exemplary damages may be granted if the defendant acted with gross negligence. Now, going in depth for actual and compensatory damages, these are damages which are recoverable because of pecuniary loss in business, trade, property, profession, job, or occupation. These damages are awarded in satisfaction of or in recompense for loss or injury sustained. Under both the Spanish Civil Code and the American Law of Damages, actual damages for a negligent act or omission are confined to those which were foreseen or might have been foreseen, or those which were the natural and probable consequences or the direct and immediate consequences of the act or omission. These damages are not presumed. The claimant must prove the actual amount of loss with a reasonable degree of certainty premised upon competent proof and on the best evidence obtainable. Specific facts that could afford a basis for measuring whatever compensatory or actual damages are borne must be pointed out. Actual damages cannot be anchored on mere surmises, speculations, or conjectures. In determining actual damages, the court cannot rely on speculation, conjecture, or guesswork as to the amount. Without the actual proof of loss, the award or of actual damages becomes erroneous. Settled is the rule that he who claims actual or compensatory damages must establish and prove by competent evidence actual pecuniary loss. The claimant must prove the actual amount of loss with a reasonable degree of certainty premised upon competent proof and on the best evidence obtainable. The burden of proof is on the party who would be defeated if no evidence would be presented on either side. So again, the burden of proof is on the party who is claiming the actual damages. It is the duty of the petitioner to present the evidence to support his claim for actual damages, and he must establish his case based on a preponderance of evidence. One is entitled for actual and compensatory damages for such pecuniary loss suffered as long as he has duly proved it. The award of actual damages cannot be based on the allegations of a witness without any tangible document to support such claim. Examples of allowed evidence would be receipts, payrolls, and payslips. However, salary written in a yellow pad is not allowed, and testimony of lost business opportunity. So damages may be recovered for the loss or impairment of earning capacity in cases of temporary or permanent personal injury. The computation for the lost earnings in case of death in accordance with Villarreal versus CA is net earning capacity equals life expectancy times gross annual income minus necessary expenses, which is uh, two-thirds times 80 minus the age of death times gross annual income minus necessary expenses. For example, Pedro died at 25 with a gross annual income of 400,000 pesos and the necessary expenses of 250,000 pesos. So doing the math, the net earning capacity of Pedro would be 5,445,000 pesos. However, in People versus Rianzares, this was further simplified in net earning capacity equals life expectancy times 1/2 times gross annual income, which is two-thirds times 80 minus the age of death times 1/2 of the annual gross income. For example, Pedro died at 25 years old with a gross annual income of 400,000. So doing the math, the under the math used in People versus Rianzares, the net earning capacity of Pedro would be 7,260,000 pesos. Under the current jurisprudence of People versus Gambao, the minimum amount of civil indemnity for death caused by a crime or quasi-delict is raised to 100,000 pesos. So, in the absence of competent evidence to prove how much the victim was earning, the heirs to the victim are not entitled thereto. By way of exception, testimonial evidence may suffice if the victim was either 1. Self-employed, earning less than the minimum wage under current labor laws, and judicial notice may be taken of the fact that in the victim's line of work, no documentary evidence is available, or 2. Employed as a daily wage worker earning less than the minimum wage under current labor laws. So in Lara's Gift and Deckers Incorporated versus Midtown Industrial Sales, the Supreme Court modified the guidelines for the imposition of interest. And the salient points are 1. When the obligation is breached and it consists in the payment of a sum of money, i.e. in a loan or forbearance of money, the interest due should be that which may have been stipulated in writing. Furthermore, the interest due shall itself earn legal interest from the time it is judicially demanded. In the absence of a stipulation, the rate of interest shall be 6% per annum to be computed from default. And the second salient point is that when the judgment of the court awarding a sum of money becomes final and executory, the rate of legal interest, whether the case falls under paragraph 1 or 2, above shall be 6% per annum from such finality until its satisfaction. This interim period being deemed to be by then an equivalent to a forbearance of credit. So attorney's fees are also in the nature of actual damages where recoverable. However, they must be duly proved. These are subject to certain standards, which are 1. They must be reasonable. That is to say, they must have a bearing on the importance of the subject matter in the controversy. 2. The extent of the services rendered. And 3. The professional standing of the lawyer. In all cases, they must be addressed in a full-blown trial and not on the bare word of the parties. The reason for the award of attorney's fees must be stated in the text of the court's decision. Otherwise, if it is only stated in the dispositive portion of the decision, the same shall be disallowed on appeal. And so here we have the subrogatory right of the insured. If the plaintiff's property has been insured and he has received indemnity from the insurance company for the injury or loss arising out of the wrong or the breach of contract complained of, the insurance company shall be subrogated to the rights of the insured against the wrongdoer or the person who has violated the contract. If the amount paid by the insurance company does not fully cover the injury or loss, the aggrieved party shall be entitled to recover the deficiency from the person causing the loss or injury. So one example of this is if Pedro's car was totaled due to a collision with a bus from ABC Incorporated. The insurer paid a portion of the car's value. So Pedro may file a complaint against ABC Company for the deficiency of the totaled car.
I am Ferlin Dibuna and I will be discussing about malicious prosecution as part of nominal damages. For this topic, we will be defining what is malicious prosecution, malice and want of probable cause, the 3 elements to maintain an action for damages, and some illustrative cases. What is malicious prosecution? It is defined as an action for damages brought by one against whom a criminal prosecution, civil suit, or other legal proceeding has been instituted maliciously and without probable cause after the termination of such prosecution, suit, or other proceeding in favor of the defendant therein. The gist of the action is the putting of legal process in force regularly for the mere purpose of vexation or injury, as stated in the case of Drilon v. Court of Appeal. What constitutes malicious prosecution? Number 1, there must be proof that the prosecution was prompted by a design to vex and humiliate a person, and number 2, that it was initiated deliberately by the defendant knowing that the charges were false and groundless. Conceitedly, the mere act of submitting a case to the authorities for prosecution does not make one liable for malicious prosecution, as stated in the case of Yasuna v. Ramos. Some cases. The filing of a suit by itself does not render a person liable for malicious prosecution. Neither does the mere dismissal by the fiscal of the criminal complaint a ground for an award of damages for malicious prosecution if there is no competent evidence to show that the complainant had acted in bad faith. Moreover, the adverse result of the action does not per se make the action wrongful and subject the action to damages, for the law could not have meant to impose a penalty on the right to litigate. If damages result from a person's exercise of a right, it is danum absque injura. Malice and want of probable cause. Malice is defined as an essential to the maintenance of an action for malicious prosecution and not merely to the recovery of exemplary damages. But malice alone does not make one liable for malicious prosecution, where probable cause is shown even where it appears that the suit was brought for the mere purpose of vexing, harassing, and injuring his adversary. In other words, malice and want of probable cause must both exist in order to justify the action. Probable cause is the existence of such facts and circumstances as would excite the belief in a reasonable mind acting on the facts within the knowledge of the prosecutor that the person charged was guilty of the crime, or in this case, the wrongdoing, for which he was prosecuted. Where there is probable cause, the charge of malicious prosecution is then defeated, regardless of considerations of malice, as stated in the case of Ponzi versus Legaspi. What are the elements of malice and want of probable cause? The elements of want of probable cause and malice must simultaneously exist, otherwise, the presence of a probable cause signifies, as a legal consequence, the absence of malice. On this, there must be proof that the prosecution was prompted by a sinister design to vex and humiliate a person, and that it was initiated deliberately, knowing that the charge was false and baseless to entitle the victim to damages. Foundation of an action is an original proceeding, judicial in character. Generally, malicious prosecution refers to unfounded criminal actions and has been expanded to include unfounded civil suits just to vex and humiliate the defendant despite the absence of a cause of action or probable cause. The foundation of an action for malicious prosecution is an original proceeding, judicial in character. A disbarment proceeding, being judicial in character, may therefore be the basis for a subsequent action for malicious prosecution, as stated in the case of Ponzi versus Legaspi. What are the three elements to maintain an action for damages based on malicious prosecution? First, the fact of the prosecution and the further fact that the defendant was himself the prosecutor and that the action was finally terminated with an acquittal. Second, that in bringing the action, the prosecution acted without probable cause, and third, the prosecutor was actuated or impelled by legal malice, as in the case of Ferrer versus Vergara. Where one is a mere witness, he cannot be held liable for malicious prosecution. The general rule. In the absence of any statutory provision to the contrary, that advice of counsel is complete defense to an action for malicious prosecution, where it appears that the prosecution was instituted in reliance in good faith on such advice, given after a full and fair statement of all the facts to the attorney. In case where it appears that aside from the case of Barr, petitioner, with blind persistence, had filed case against and complaint after complaint against Aurelia Altea and her common-law husband, and not a single case prospered, moral damages was validly awarded, as in the case of Hopia versus Court of Appeals. Grant of moral damages is not subject to the whims and caprices of judge of courts. The grant of moral damages is not subject to the whims and caprices of judges or courts. The court's discretion in granting or refusing it is governed by reason and justice. In order that a person may be made liable to the payment of moral damages, the law requires that his act be wrongful. The adverse result of an action does not per se make the act wrongful and subject the actor to the payment of moral damages. The law could not meant to impose a penalty on the right to litigate. Such right is so precious that moral damages may not be charged on those who may exercise it erroneously. For this, the law taxes cost, as in the case of Barreto versus Arevalo. Award of damages under Article 19, 20, and 21. The elements of abuse of right under Article 19 are the following: the existence of a legal right or duty, number 2, which is exercised in bad faith, and third, for the sole intent of prejudicing or injuring another. Article 20 speaks of the general sanction for all other provisions of law which do not specially provide for their own sanction, while Article 21 deals with acts contra bonus mores and has the following elements. First, there is an act which is legal. Second, but which is contrary to morals, good custom, public order, or public policy. And third, and it is done with intent to injure. Breach of promise to marry. Where a man's promise to marry is in fact the proximate cause of the acceptance of his love by a woman, and his representation to fulfill that promise thereafter becomes the proximate cause of the giving of herself unto him in a sexual congress, and that he had in reality no intention of marrying her, and that the promise was only a subtle scheme or deceptive device to entice or inveigle her to accept him and to obtain her consent to the sexual act, the act would justify the award of damages. Pursuant to Article 21, not because of such promise to marry, but because of the fraud and deceit behind it, and the willful injury to her honor and reputation which followed thereafter. Culpa contractual cases. Damages are not recoverable in culpa contractual except where the presence of bad faith was proven, as in the case of Transworld Airlines versus Court of Appeals. However, in breach of contract of carriage, moral damages may be recovered when it results in the death of a passenger, as in the case of Philippine Rabbit Bus Lines Incorporated versus Isguera. In culpa contractual or breach of contract, moral damages may be recovered when the defendant acted in bad faith or was guilty of gross negligence, which amounts to bad faith, or in wanton disregard of contractual obligations, and, as in this case, when the act of breach of contract itself constitutes the tort that results in physical injuries. By special rule in Article 1764 in relation to Article 2206 of the Civil Code, moral damages may also be awarded in case the death of a passenger results from a breach of contract of carriage, as in the case of Victoria Liner versus Gamat. Bad faith in this context includes gross but not simple negligence, as in the court of FEBTC versus Court of Appeals. Although the rule is that moral damages predicated upon a breach of contract of carriage may only be recoverable in instances where the mishap results in the death of a passenger or where the carrier is guilty of fraud or bad faith, there are situations where the negligence of the carrier is so gross and reckless as to virtually amount to bad faith, in which case the passenger likewise becomes entitled to recover moral damages, as stated in the case of Singson versus Court of Appeal. When moral damages may be recovered. In culpa contractual or breach of contract, moral damages may be recovered when the defendant acted in bad faith or was guilty of gross negligence, amounting to bad faith, or in wanton disregard of his contractual obligation. Since the law presumes good faith, the persons claiming moral damages must prove bad faith or ill motive by clear and convincing evidence, as in the case of MOF Company versus Enriquez. Some cases related to culpa contractual, Lopez versus Pan American World Airways states that when it comes to contracts of common carriage, inattention and lack of care on the part of the carrier, resulting in the failure of the passenger to be accommodated in the class contracted for amounts to bad faith or fraud, which entitles the passenger to the award of moral damages in accordance with Article 2220 of the Civil Code. Also in the case of Saviliano et al. Versus Northwest Airlines, it states that good faith is presumed, while bad faith is a matter of fact that needs to be proved by the party alleging it. Article 2219 of the Civil Code enumerates the instances in which moral damages may be awarded. In a breach of contract, such damages are not awarded if the defendant is not shown to have acted fraudulently or with malice or bad faith. In the case of BPI Express Card Corporation versus Court of Appeals, it states that not every act of dishonor of credit card will entitle one to moral damages, where the suspension is brought about by the non-payment of one's outstanding account, the dishonor is held to be without malice and is not in abuse of right. Lastly, in Herbosa et al. Versus Court of Appeals, it states that for the wanton and reckless failure and neglect to timely check and remedy the videotape recorder such that no pictures registered after the few snatches of the bride, the Supreme Court ruled that moral damages are due. The failure to record and videotape the wedding celebration constitutes malicious breach of contract as well as gross negligence. Thank you and good evening.
My topic is nominal damages. Definition: nominal damages are adjudicated in order that a right of the plaintiff which has been violated or invaded by the defendant may be vindicated or recognized, and not for the purpose of indemnifying the plaintiff for the loss suffered by him. Can nominal damages be awarded in every obligation? The court may award nominal damages in every obligation arising from any source enumerated in Article 1157, or even in every case where any property right has been invaded in Article 2222 of the Civil Code. In P&OC Shipping and Transport Corporation versus Court of Appeals, nominal damages are damages in name only and not in fact. Where these are allowed, they are not treated as an equivalent of a wrong inflicted, but simply in recognition of the existence of a technical injury. In Saludo Jr. et al. Versus Court of Appeals, Articles 2221 and 2222 of the Civil Code make it clear that nominal damages are not intended for indemnification of the loss suffered, but for the vindication or recognition of a right violated or invaded. They are recoverable where some injury has been done but the amount of which the evidence fails to show the assessment of damages being left to the discretion of the court according to the circumstance of the case. Lufthansa German Airlines versus Court of Appeals. In the absence of competent proof on the actual damage suffered, private respondent is entitled to nominal damages, which, as the law says, is adjudicated in order that a right of the plaintiff, which has been violated or invaded by the defendant, may be vindicated or recognized, and not for the purpose of indemnifying the plaintiff or the loss suffered. It is an established rule that nominal damages cannot coexist with compensatory damages. This is because the two stand totally in a different jural foundations. Nominal damages are awarded not to indemnify one for its loss, but to recognize a right that has been violated, whereas compensatory damages are awarded to the precise purpose of reparation and indemnification. In cases involving dismissals for cause but without observance of the twin requirements of notice and hearing, it was held that the better rule is when filled, by holding that the dismissal was for just cause, but imposing sanctions on the employer. In fixing the amount of nominal damages to be awarded, the circumstances of each case should thus be taken into account, such as, to exemplify, first, the length of service or employment of the dismissed employee. Second, his salary or compensation at the time of the termination of employment and the capability of the employer to pay. Third, question whether the employer has deliberately violated the requirements for termination of employment or has attempted to comply at least substantially therewith. Fourth, the reasons for the termination of the employment. Just and authorized cause. Accordingly, if the dismissal is based on a just cause under Article 282 but the employer failed to comply with the notice requirement, the sanction to be imposed upon him should be tempered because the dismissal process was, in effect, initiated by an act imputable to the employee. In this instance, nominal damages is invariably fixed at 30,000. Second, if the dismissal is based on authorized cause under Article 283 but the employer failed to comply with the notice requirement, the sanction should be stiffer because the dismissal process was initiated by the employer exercise of his management prerogative. The nominal damage is at 50,000. This is in the case of Jaka Processing Food Corporation versus Pakot. In Lara versus Derm Pharma Incorporated, the court held that the dismissal was for just cause, but the non-observance of procedural due process warranted the award of 50,000 as nominal damages. Air France versus Zany, a passenger who was forced to rebook his flight, rearrange his schedule and business meetings, and suffer confusion and frustration because of his missed flight, was awarded 50,000 as nominal damages. Where no right of the petitioner was violated or invaded, nominal damages cannot be awarded, as in Solid Homes Incorporated versus Court of Appeals. Algara versus Sandejas. If no damages have actually occurred, there can be none to repair, and the doctrine of nominal damages is not applicable. Thus, it has been often held that mere non-compliance with the obligation of a contract is not sufficient to sustain a judgment for damages. It must be shown that the damages actually existed. Grant of nominal damages is a bar to recovery of actual, moral, temperate, and moderate damages. When nominal damages are already awarded, it is no longer proper to award further in terms of actual, moral, temperate, or moderate damages. In Article 2223, the adjudication of nominal damages was preclude further contest upon the right involved and all accessory questions as between the parties to the suit or their respective heirs and assigns.
Temperate or moderate damages. Legal basis. Article 2224 New Civil Code and Article 2225 New Civil Code. Requisites, requirements for the award. First is actual existence of pecuniary loss. Second is the nature and circumstances of the loss prevents proof of the exact amount. Third, they are more than nominal and less compensatory. Fourth, causal connection between the loss and the defendant's act or omission. And fifth, amount must be reasonable. Nature and concepts. According to the case of Equitable PCI Bank versus Tan, the allowance of temperate damages when actual damages were not adequately proven is ultimately a rule drawn from equity, the principle affording relief to those definitely injured who are unable to prove how definite the injury. Temperate damages may be awarded in the following cases: in lieu of actual damages and in lieu of loss of earning capacity. According to the case of MBTC versus CA, temperate damages may be allowed in cases where, from the nature of the case, definite proof of pecuniary loss cannot be adduced, although the court is convinced that there has been such loss. According to the case of Barsaga versus CA, in cases where the amount of pecuniary loss could, by their very nature, be established with certainty, it is an error to award temperate damages. The rationale behind the temperate or moderate damages are according to the case of GSIS versus Spouses Labung Diang, is precisely from the nature of the case. Definite proof of pecuniary loss cannot be offered. When the court is convinced that there has been such loss, the judge is empowered to calculate moderate damages rather than let the complainant suffer without redress from the defendant's wrongful act. Damages table. Temperate damages, according to its purpose, is when the court is convinced that there has been such a loss. The judge is empowered to calculate moderate damages rather than let the complainant suffer without redress. It is from the case before the GSIS versus Labong Liang. Temperate damages, in the manner of determination, may be recovered when the court finds that some pecuniary loss has been suffered but its amount cannot, from the nature of the case, be proved with certainty. No proof of pecuniary loss is necessary. Temperate damages are special damages. Special damages are those which exist because of the special circumstances and for which a debtor in good faith can be held liable if he had been previously informed of such circumstances. Cases or instances where temperate damages are adjudicated. According to the case of People versus Orbes, the trial court awarded 20,000 as actual damages not supported by evidence on record. Actual damages can be given only to claims which are duly supported by receipts. Nonetheless, under Article 2224, in lieu of actual damages, temperate damages may be recovered as it has been shown that the victim's family suffered some pecuniary loss, although the amount cannot be proved with certainty. For this reason, the 20,000 award shall be for temperate damages. Further, conformably with prevailing jurisprudence, moral damages increased to 50,000. According to the case of People versus Abes, where the court finds that some pecuniary loss has been incurred, but the amount cannot be proved with certainty, such as for medical services and the wake, temperate damages are appropriately given. In a bar exam in 1994, a question was asked on temperate damages. Question: on January 5, 1992, Nonoy obtained a loan of 1 million from his friend Rafi. The promissory note did not stipulate any payment of interest. The note was due on January 5, 1993, but before this date, the two became political enemies. Nonoy, out of spite, deliberately defaulted in paying the note, thus forcing Rafi to sue him. Can Rafi ask for temperate damages? Answer: Rafi may ask for, but would most likely not be awarded temperate damages, for the reason that his actual damages may already be compensated upon proof thereof with the promissory note. Temperate damages may be awarded only when the court finds that some pecuniary loss has been suffered but its amount cannot from the nature of the case be proved with certainty, according to Article 2224 of the New Civil Code. Related cases. Case Digest Number 1. Nanito Evangelista versus Spouses Andolong et al. Facts of the case. Nanito Evangelista filed a complaint for damages against Andolong over the latter's failure to give the former share in the net profits derived from their business. However, this was evidenced solely by the documentary exhibits which disclosed the gross monthly revenue and not the actual profit earned. During the course of the proceedings, Andolong was declared in default. Consequently, it was no longer possible for Evangelista to prove the actual profit earned, since such documents were in possession of Andolong. Issue of the case: whether or not Evangelista will recover damages if the net profits can no longer be ascertained. Ruling: yes. Evangelista can recover damages, although the exact amount of the net profits remained unproven. This comes in the form of temperate or moderate damages. Temperate damages may be recovered when the court finds that some pecuniary loss has been suffered but its amount cannot, from the nature of the case, be provided with certainty. Consequently, in computing the amount of temperate and moderate damages, it is usually left to the discretion of the courts, but the amounts must be reasonable, bearing in mind that temperate damages should be more than nominal but less than compensatory. Case Digest Number 2. Marlon Basera Tabones versus People of the Philippines. Facts of the case. Alfredo and his family were sound asleep in their home. At about 1 a.m., he was roused from sleep by the sound of stones hitting his house. Alfredo went into the living room and peered through the jalousie of the window. The terrace light allowed him to recognize his neighbor and co-worker Basera. But just as he was about to leave, Basera exclaimed, "Vulva of your mother, old Fred, I'll burn you now," at around 4 o'clock a.m. He heard the dogs barking outside. Alfredo looked outside the window and saw Basera walking toward their nipa hut, which was located around 10 meters from their house. Basera paced in front of the nipa hut and shook it. Moments later, Alfredo saw the nipa hut burning. Alfredo sought help from his neighbors to smother the fire. Edgar contacted the authorities for assistance, but it was too late. The nipa hut and its contents were completely destroyed. RTC held Basera guilty and awarded 50,000 pesos to Alfredo as temperate damages. The issue of the case: whether or not the award of temperate damages amounting to 50,000 will prosper. The ruling of the case is yes. Under Article 2224 of the Civil Code, temperate damages may be awarded when there is a finding that some pecuniary loss has been suffered, but its amount cannot, from the nature of the case, be proved with certainty. The amount of temperate damages to be awarded in each case is discretionary upon the courts, as long as it is reasonable under the circumstances. Private complainant clearly suffered some pecuniary loss as a result of the burning of his nipa hut. However, private complainant failed to substantiate the actual damages that he suffered. Nevertheless, he is entitled to be indemnified for his loss. The award of the temperate damages amounting to 50,000 is proper and reasonable under the circumstances.
Hello everyone, my name is Jobert O. Bagaporo, and I'm going to report about liquidated damages. Based on the provisions of Article 2226 of the New Civil Code, Liquidated damages are those agreed upon by the parties to a contract to be paid in case of breach thereof. In the case of Philippine Economic Zone Authority versus Ilhino Sales Corporation, the court declared that liquidated damages are those that the parties agreed to be paid in case of a breach. As worded, the amount agreed upon answers for damages suffered by the owner due to delays in the completion of the project. Under Philippine laws, these damages take the nature of penalties. A penal clause is an accessory undertaking to assume greater responsibility or liability in case of a breach. It is attached to an obligation in order to ensure performance. By definition, liquidated damages are a penalty meant to impress upon defaulting obligors the graver consequences of their own culpability. Liquidated damages must necessarily make non-compliance more cumbersome than compliance. Otherwise, contract might as well make no threat of a penalty at all. Liquidated damages is attached to an obligation in order to ensure performance and has a double function. One, to provide for liquidated damages, and two, to strengthen the coercive force of the obligation by the threat of greater responsibility in the event of breach. The amount agreed upon answers for damages suffered by the owner due to delays in the completion of the project. As a precondition to such award, however, there must be proof of the fact of delay in the performance of the obligation. This is pronounced in the case of Atlantic Erectors Incorporated versus Court of Appeals. What is the basis of award of liquidated damages? The Atlantic Erectors case asserted that as a precondition to such award, however, there must be proof of the fact of delay in the performance of the obligation. What is decisive of such entitlement is the fact of delay in the completion of the works. Stated in simple terms, as long as the contractor fails to finish the work within the period agreed upon by the parties without justifiable reason, and after the owner makes a demand, then liability for damages as a consequence of such default arises. When the obligor refuses or fails to satisfactorily complete the works under the contract within the specified contract duration, plus any time extension duly granted, and is thus considered in default under the contract, it will be liable for liquidated damages for the delay. To continue, we will learn how to determine the amount of liquidated damages to be awarded in case of a breach. The award of liquidated damages are those that the parties agreed to be paid in case of a breach. Under Philippine laws, these damages take the nature of penalties. Penal clause is an accessory undertaking to assume greater liability in case of a breach. It is attached to an obligation in order to ensure performance. Moreover, liquidated damages are identical to penalty insofar as legal results are concerned, intended to ensure the performance of the principal obligation. Such damage are accessory and subsidiary obligation. In the case of Titan versus Unifield, it is stated that a stipulation on liquidated damages is a penalty clause where the obligor assumes a greater liability in case of breach of an obligation. The obligor is bound to pay the stipulated amount without need of proof on the existence and the measure of damages caused by the breach. Based on the provisions of Article 2227 of the New Civil Code, liquidated damages, whether intended as an indemnity or penalty, shall be equitably reduced if they are iniquitous or unconsumable. However, under Article 2228 of the New Civil Code, when the breach of a contract committed by the defendant is not the one contemplated by the parties in agreeing upon the liquidated damages, the law shall determine the measure of damages and not the stipulation. As we have just learned, liquidated damages is based on the agreement of the parties as stipulated in the contract. Now, the question is, what is the effect of an invalid contract to the claim of liquidated damages? The court, speaking through the case of Chavez versus Ives, declared that since the principal obligation was void, there was no contract that could have been breached by petitioners. Thus, the stipulation on liquidated damages was inexistent. The nullity of the principal obligation carried with it the nullity of the accessory obligation of liquidated damages. No damages may be recovered on the basis of a void contract. Being non-existent, the agreement produces no juridical tie between the parties involved. Since there is no contract, the injured party may only recover through other sources of obligations, such as a law or a quasi-contract. A party recovering through these other sources of obligations may not claim liquidated damages, which is an obligation arising from a contract. Daghang salamat ug dalaygon ang Dios.
Let's go to related bar questions and case digests. But I will not read to you all the slides here. I will just pick up some of the bar questions and case digests, because if I'm going to read all or present everything we have, then it takes us more or less 1 hour to finish. So I'll just pick up some. For bar questions, Primo owns a pet iguana which he keeps in a man-made pond enclosed by a fence situated in his residential lots. A typhoon knocked down the fence of the pond, and the iguana crawled out of the gate of Primo's residence. And a neighbor who was passing by started throwing stones at the iguana, drawing the iguana to move toward him. And panicked and ran, but tripped on something and suffered a broken leg. Is anyone liable for N's injuries? Answer: no one is liable. The possessor of an animal or whoever may make use of the same is responsible for the damage which it may cause, although it may escape or be lost. This responsibility shall cease only in case the damage should come from force majeure or from the fault of the person who has suffered damage. Another one, it's all about nuisance. A house of prostitution. Answer: irrespective of its location and how its business is conducted, it is a nuisance since it defies, shocks, regards decency and morality. It is a public nuisance because of its injury to the public. A noisy or dangerous factory in a private land. The answer: if the noise injuriously affects the health and comfort of ordinary people in the vicinity to an unreasonable extent, it is a nuisance. It is public nuisance because there is a tendency to annoy the public. Let's go to another. Our internet connection is very slow. Let's go to kinds of damages. For bar question. On January 5, 1992, Nonoy obtained a loan of 1 million from his friend Rafi. The promissory note did not stipulate any payment for interest. The note was due on January 5, 1993, but before this date, the two became political enemies. Nonoy, out of spite, deliberately defaulted in paying the note, thus forcing Rafi to sue him. What actual damages can Rafi recover? Can Rafi ask for moral damages from Nonoy? Can Rafi ask for nominal damages? Can Rafi ask for temperate damages? Can Rafi ask for attorney's fees? The answer, suggested answer. Rafi, these are the suggested answers. For the answer of the first problem, Rafi may recover the amount of the promissory note of 1 million, together with interest at the legal rate from the date of judicial or extrajudicial demand. In addition, however, inasmuch as the debtor is in bad faith, he is liable for all damages which may be reasonably attributed to the non-performance of the obligation. Answer to the second question. Yes, under Article 2220 New Civil Code, moral damages are recoverable in case of breach of contract where the defendant acted fraudulently or in bad faith. Answer to number 3. Nominal damages may not be recoverable in this case because Rafi may already be indemnified of his losses with the award of actual and compensatory damages. Nominal damages are adjudicated only in order that a right of the plaintiff, which has been violated or invaded by the defendant, may be vindicated or recognized, and not for the purpose of indemnifying the plaintiff for any loss suffered by him. And for number 4, Rafi may ask for, but would most likely not be awarded temperate damages, for the reason that his actual damages may already be compensated upon proof thereof with a promissory note. Temperate damages may be awarded only when the court finds that some pecuniary loss has been suffered, but its amount cannot, from the nature of the case, be proved with certainty. Fifth, yes, under paragraph 2, article 2208 of the Civil Code, considering that Nonoy's act or omission has compelled Rafi to litigate to protect his interest. Furthermore, attorney's fees may be awarded by the court when it is just and equitable. Let's go to the case digest. We'll just pick some of the related digests in Case Digest. Our connection is very slow. Just wait a second. Okay, here, sample. In the case of Iloilo Ice and Cold Storage Company versus the Municipality Council of Iloilo, Iloilo Ice and Cold Storage Company, upon authority granted by the Municipal Council of Iloilo, constructed an ice and cold storage plant in Iloilo. After the plant had been completed and was in operation, nearby residents made complaints to the defendant that the smoke from the plant was very injurious to their health and comfort. The issue in this case is that whether the ice and cold storage is a nuisance. Ruling, in the present case, it is certain that the ice factory of the plaintiff is not a nuisance per se. It is a legitimate industry, beneficial to the people, and conducive to their health and comfort. If it be in fact a nuisance due to the manner of its operation, that question cannot be determined by the mere resolution of the board. The petitioner is entitled to a fair. Another case talks about exemplary damages. People of the Philippines versus Joseph Aurelia. That on or about the dawn of September 12, 1996 at Barangay Masiden, Municipality of Bani, Province of Pangasinan, and within the jurisdiction of this Honorable Court, the above accused Joseph Aurelia, by means of force or intimidation, armed with a knife, did and then there willfully and lawfully and feloniously have sexual intercourse with Remelin Aurelia, younger sister of accused, against her will and consent, to her damage and prejudice. The issue in this case, whether Remelin Aurelia is entitled to exemplary damages. The ruling, the decision of the Regional Trial Court, 1st Judicial Region, Branch 54, Alamina City, Pangasinan, is affirmed insofar as it finds appellant Joseph Aurelia guilty of 1 count of rape in criminal case, with the modification that the death sentence imposed is reduced to reclusion perpetua and the amount of civil indemnity is reduced to 50,000. In addition, appellant is further ordered to pay Remelin Aurelia 50,000 for moral damages, 25,000 exemplary damages. Criminal case number 3220 is dismissed. The provision recommending the disqualification of appellant from executive clemency is deleted. In the case of Oscar Ventanilla versus Gregorio Centeno, when damages may be recovered. In this case, the issue in this case, whether appealee is entitled to recover moral damages. In the ruling of the court, moral damages are recoverable only when physical suffering, mental anguish, fright, serious anxiety, besmirched reputation, wanted feelings, moral shocks, social humiliation, and similar injury are proximate result of a criminal offense, resulting in physical injuries, quasi-delicts, causing physical injuries, seduction, abduction, rape, or other lasciviousness acts, adultery or concubinage, illegal or arbitrary detention or arrest, illegal search, libel, slander, or any other form of defamation, malicious prosecution, disrespect for the dead, or wrongful interference with the funerals, violation of specific provisions of the Civil Code on Human Relations, and willful injury of property. To this, we may add that where a mishap occurs resulting in death of a passenger being transported by a common carrier, the spouse, descendants, and ascendants of the deceased passenger are entitled to demand moral damages for mental anguish by reason of the passenger's death. Okay, but in our slides, we have lots of case digest and bar questions. So just let us know if you need our soft copy. Thank you.